Our keynote speaker for tonight is someone that might be familiar to many of you who follow the anti-war and foreign policy movements. Patrick MacFarlane. Patrick lives in Wisconsin and is a criminal defense and family law attorney. He is the Justin Raimondo Fellow at the Scott Horton's Libertarian Institute, where he advocates a non-interventionist foreign policy. His podcast, Vital Dissent, exposes establishment narratives in foreign policy with well-researched documentary content and insightful guest interviews. His work has appeared on antiwar.com, the Ron Paul Institute, and Zero Hedge. Please join me in welcoming Patrick MacFarlane.
All right, everybody, thank you. I really appreciate that introduction, and I hope I live up to the main event here this evening. This locked here?
Working on it.
I just want to make sure I'm projecting. That looks good. Am I coming through the speakers here?
Good. Is it dead?
Check 1, 2. There it is. Okay. A little bit closer. Okay. Well, first off, I'd like to thank Tom Leary and Tim Krenz for the opportunity to speak here tonight. I really do appreciate it. It's a great honor for me. I'd also like to say hi to my son, Thomas, who I understand is up late past his bedtime watching on the live stream. So hopefully he doesn't stay up too late tonight. So on March 19th, 2003, on the eve of Iraq War II, the late great Justin Raimondo of antiwar.com hunched over a keyboard with his brow furrowed, with a cigarette jutting from his iconic scowl, and punched out a polemic called Shine Perishing Republic. Raimondo's piece, of course, was hearkening back to the 1925 anti-imperialist poem of the same name by a poet named Robinson Jeffers. Shine Perishing Republic lamented America's departure from the old republic. And that poem tied together many of the themes that libertarians know all too well. Everyone sitting in this room here tonight knows it, that empire abroad leads to loss of liberty at home. And as a part of that piece, Justin Raimondo wrote, "As the sand in the hourglass runs down and the Grim Reaper gets ready for harvest time in Iraq, I think of the poetry of Robinson Jeffers and of the poet himself, a difficult man, serenely alienated from the world of his time, whose poems echo down through the years like the voice of some forgotten prophet who got it all right, too right. He was bitterly opposed to World War II. In describing his president, he wrote of, quote, the cripple's power, need of Roosevelt. Jeffers' bitterness was turned into a thing of beauty when he put pen to paper." And this is what Jeffers wrote in this poem. And I think we should keep all this in mind as the news came tonight that Iran has hit Israel with rocket strikes and drone strikes as well. And we're possibly being drugged into another conflagration. Jeffers wrote, "While this America settles in the mold of its vulgarity, heavily thickening to empire, and protest only a bubble in the molten mass pops and sighs out, and the mass hardens, I sadly smiling remember that the flower fades to make fruit, the fruit rots to make earth. Out of the mother and through the spring exultances, ripeness and decadence, and home to the mother. You making haste on decay, not blameworthy, life is good, be it stubbornly long or suddenly. A mortal splendor, meteors are not needed less than mountains. Shine Perishing Republic." So like Jeffers, Raimondo had a way of turning aggressively dissident anti-war editorializing into an art form, one that tied an encyclopedia of facts together with culture, literature, and scathing wit, because we all need more of that. Raimondo, of course, is a large influence on my activism personally, as America continues plummeting into the imperial abyss. It is the death spiral of America's post-Cold War unipolar moment, something that the neoconservatives hubristically called the end of history. For the last 12 years, I've witnessed this death spiral as I've grown up in the liberty movement. I'm 30 years old today, well, not today, but this year, which is crazy to think about. And I'm sure a lot of people in this room who are a bit older than that might kind of scoff at that. But it's true, 30 is a big number for me. As a college freshman at the University of Minnesota, I fell in love with the 2012 Ron Paul presidential campaign. Maybe a lot of you folks can relate to that, and people listening at home. After graduation, I continued on to law school at Mitchell-Hamlin in St. Paul, and during my 2L year, I was 23 years old. I was a full-time law student. I had just gotten married. I was a law clerk at the Public Defender's Office in Anoka County, and I was editing for a school publication, you know, writing things about how we just need to decriminalize all drugs and how we need to replace the police with private security firms, which some of my law professors found interesting, but I think they just found it interesting. I thought it'd be a great idea with all those things on my plate to start a weekly podcast, and I think I have Tom Woods to blame for that, along with a lot of people. So in February 2018, I found something called the Libertarian Institute, and I wrote them an email asking if I could post my podcast there, and they said yes. But somehow I didn't know that, at the time I didn't know that Scott Horton was the director of the Institute, and it was him that said yes to allowing me to post my content on the Institute. And I've been there ever since. So in 2018, a year later, I graduated from law school and I passed the bar exam and started practicing. Now I have my own law firm. It's a solo practice, and I mostly do criminal defense and family law. I have no idea how, but during that time I've managed to continue my activism alongside this career. And also through that, 8 years of happy marriage to my lovely wife, and she's given me 3 wonderful boys. One of which I hope is watching right now. Like many people, becoming a father really made me worry about what kind of country and nation that my boys are going to grow up in. Now, the Biden administration says that that nation is the leader of something called, quote, the rules-based international order. I don't know if you guys have heard of this term. The idea being that the United States is uniquely entitled to enforce neoconservative and neoliberal progressive democratic hegemony across the world. Of course, in practice, we all know what this looks like and what it means. It means destroying the Middle East. It means killing over 1 million Iraqis. It means being in Afghanistan for over 20 years and then having the entire country just collapse. The government that we spent the last 20 years propping up. And it happened in like a week. It means NATO expansion. It means provoking and fighting proxy wars against the world's largest nuclear power. It means confronting China on China's doorstep. It means funding and arming Israel in what the International Court of Justice says could plausibly be classified as an ongoing genocide. And tonight we're seeing what that bears fruit, what fruit that bears. The war with Iran that the United States has wanted and has provoked for the last 20 or 30 years. All of this comes at the risk of entangling the United States in a regional or even a world war. And with all this imperial hubris lies the contradiction that Raimondo underscored in his piece, Shine Perishing Republic. What kind of libertarian vision does one enforce at the point of a gun? And what kind of liberty is left for the shooter after the trigger is pulled? Our glorious leaders repeatedly bandy about the official boilerplate, human rights in a free, open, and fair world. That's something that came from the mouth of Secretary of State Antony Blinken. Often this comes in the context of criticizing perceived authority. Often this comes in the context of criticizing perceived authoritarianism abroad in other countries. None of our business. There is no clear demonstration of this contradiction than the crisis that is currently facing the American justice system. And of course, meanwhile, at home, we're struggling on a massive scale to guarantee our citizens their most basic American liberties. 2 years ago, in 2022, Wisconsin suffered national embarrassment when a group of criminal defendants in Brown County, Wisconsin, filed a class action civil rights lawsuit against Governor Evers. And their claim was that Governor Evers failed to appoint them legal counsel when they were facing criminal prosecution. The complaint begins: the United States Constitution and the Wisconsin Constitution guarantee that people accused of crimes have the right to the assistance of an attorney for their defense. The U.S. Supreme Court has recognized that this right to counsel is, quote, a bedrock principle that constitutes the very foundation of our adversarial legal system of criminal justice. The Wisconsin Supreme Court has emphasized that, quote, the right to counsel in criminal proceedings is a fundamental constitutional right and a cornerstone of our justice system, because lawyers in criminal courts are necessities and not luxuries. The United States Constitution and the Wisconsin Constitution require Wisconsin to appoint counsel to indigent defendants within a reasonable time after the defendant's initial appearance. Likewise, the Wisconsin legislature passed a set of laws that were supposed to, quote, provide for a prompt determination of indigency and appoint a public defender. And prompt means without undue delay. Indeed, the Wisconsin Supreme Court has, quote, condemned delays in the appointment of counsel that take longer than 10 to 14 days, consistently finding such delays to be unreasonable. But Wisconsin consistently takes longer than 14 days to provide counsel to indigent criminal defendants. This failure to provide timely legal representation is a statewide problem, according to the complaint. And it's admitted that it will take years to clear a backlog of roughly 35,000 cases. Now, this lawsuit was filed 2 years ago, so they were kind of dealing with, the fallout from COVID and all that kind of stuff. But this is a systematic problem that preceded COVID-19. Now, this complaint that was filed in Brown County was an astounding 418 pages long. And the reason it was so long is because the plaintiffs attached a 388-page spreadsheet listing thousands of individual criminal defendants that were awaiting the appointment of an attorney. Now, not all those folks were sitting in jail, but many of them were. A lot of them were released on bond, but they were released on bond sitting there. I don't know if any of you are facing criminal prosecution, but for a lot of my clients, criminal prosecution is the most important thing going on in their lives. I mean, I spoke with someone here today before who was facing felony prosecution, and he said that his case was waiting 4 years with the felony prosecution hanging over your head. It's unacceptable. Now, this complaint was 418 pages long, but the kicker is that the 388 pages that were just the spreadsheet of people waiting for attorneys, that was only defendants from 25 of Wisconsin's 72 counties. So that should put it into perspective for all of you. Now, as an advocate of liberty and a criminal defense attorney, I have a little bit of perspective on this. Let me explain how the appointment process goes. So a defendant is served with a criminal complaint. They have an initial appearance. And if they're in custody, the public defender's office will evaluate them, even if they're not in custody. But the public defender's office will evaluate them and ask about their income. And that is to determine if they qualify for a publicly appointed attorney. And if it does, a full-time staff, when I say a full-time staff public defender, the public defender that's appointed to them usually is an employee of the government. usually this will happen that a government employee, a government public defender will be appointed to represent them if they're lucky. Now, if they're unlucky, the state public defender's office might be ethically prohibited from representing them. There might be a conflict. Usually this happens when there is co-defendants, because the state public defender's office can't represent co-defendants in the same crime. They'd be conflicted out of that. So what happens to these folks who qualify for a public defender, but the public defender's office is ethically conflicted out of representing them? Well, they hire someone like me, a private attorney who sometimes accepts public defender appointments. The problem is, though, that public defender cases for private attorneys pay less than half of the private rate. So for decades in Wisconsin, the rate was locked at $40 an hour, which to a lot of folks here, I understand that $40 an hour might seem like a good wage. And I mean, for all intents and purposes, it is a good wage. But for an attorney, someone who's gone through law school, has established a practice and specialized in this area of high demand, that's not very much. So the rate was locked at $40 an hour from 1995 to around 2018 or 2019. And in 2019, the rate was increased from $40 to $70 an hour. For comparison, attorneys in private practice can charge private clients $300 to $350 per hour. So in response to the Brown County lawsuit, the private bar public defender rate was increased to $100 per hour, which is where it stands right now. Now keep in mind, $100 an hour, there's overhead, there's a lot of things that come out of that, so it doesn't all go in the attorney's pocket. So it's $100 right now, but it's clear that this pay raise did not solve the underlying problems of getting people represented. Now, full disclosure again, I personally do accept contract public defender work as a private attorney. So I do have an interest in getting the rate raised myself, but it's still way too low. And that's not just borne out by, hey, Patrick MacFarlane is standing up here and saying, I want to be paid more. No, it's these people still aren't getting appointed counsel because it's really hard to attract private attorneys to accept public cases and to accept a third of the pay they would get otherwise. But in preparation for my speech here tonight, I spoke with Katie York, and she's the head of Wisconsin State Public Defender System. I also spoke with Adam Plotkin, and he's the State Public Defender's legislative liaison, so he's worked on this pretty extensively. We discussed that the public defender rate is not the only issue that comes into play here. As you'd expect, the backups in the system and getting people appointed stem from several problems that people in this room, libertarians, know all too well. One is overcriminalization. There's always more crimes going on the books, and there's never crimes coming off the books. One of them is victimless crimes. I mean, we talk about that all the time as libertarians. We know that all too well because we're uniquely settled in this understanding of property rights. But the biggest one, the biggest crime that Wisconsinites are being charged with, that's a victimless crime, aside from drug possession, is bail jumping. And I don't know how many of you folks are familiar with this concept of bail jumping. Is people are brought into court, there's a case pending, there's certain conditions put on them that they have to obey while their case is pending. And if they don't abide by those conditions, it's a new criminal offense. So if you get new charges, or if you have contact with someone you're not supposed to have contact with, or if you just don't show up to court, you get hit with a bail jumping charge. The other thing is district attorneys overcharging. Now, you would understand basically district attorneys have a broad range of discretion in deciding which charges that they personally, in their judgment, would like to bring. Well, all of the cards are stacked in their favor, and people who've ever been charged with an offense will understand this, is that when you're facing 15 felony counts, and the DA says, okay, well, you plead to 2 of them and I'll dismiss the rest, you don't want to go to trial and risk getting the conviction on the 15 counts. You'll take the 2 counts and take whatever's being offered to you. So the DAs get overconfident because all the cards are stacked in their favor, and the impetus is to settle the case. So they overcharge things because they know they have to prove, they don't really have to prove it unless someone takes it to trial, which is a huge risk. The other thing, of course, as we discussed, is the lack of funding, the lack of DA's offices and of public defenders to attract and retain talent because they can't pay very much. The other thing is that attorneys are dying and they're retiring and no one is coming in to replace them. I don't know if you've heard about this crisis of competence. It's something that's being discussed, but I don't know if that's just kind of a boomer thing of people shaking their fist at the sky and saying like, oh, well, young people, they're just, they're not competent, they're not doing what we did back in our day. I don't know, but the truth is that in rural counties especially, attorneys aren't coming. Young folks aren't coming. I said at my practice, and I'm the youngest attorney in my county, maybe the tri-county area of where I practice. I think the next oldest attorney is maybe 40 years old. So all these attorneys are dying or retiring, and no one's coming in to replace them. So we have all of those problems. On the public defender side, but in 2023, another long festering problem challenged the Wisconsin judicial system when several counties struggled to staff their respective district attorney's offices. Dodge County, Wisconsin was infamously left without any prosecutors. Now, maybe you would think that this is a great thing, and in some instances, yes, it certainly is. But in other instances, you also have to think of the rights that victims have for real legitimate crimes. And you have to think about this idea of anarcho-tyranny, okay? So when the state monopolizes something like the provision of justice, what happens if they do a really terrible job, right? I mean, it's unacceptable because if you're a victim of a crime, you have rights too. This year, it was Rusk County, Wisconsin that doesn't have any prosecutors. So as a criminal defense attorney, I certainly, it's not the worst thing ever, but it causes problems in of itself. But to be fair, the legislature did address these problems by increasing the pay. I alluded to it before, from 70 to 100. But there were raises for staff public defenders as well, and raises for prosecutors. The one thing they can offer that I don't have myself is the benefits package of the state retirement system. But these increases in the pay rates, they treated the symptoms and not the underlying cause. And that's something, as libertarians, we certainly understand the seen and the unseen effects, Bastiat's lesson, Frederick Bastiat. These problems are systemic, and only we have the solution because we truly understand it as libertarians. Now, I understand that some of us, including me, believe that the government is an unnecessary evil and not a necessary evil. However, the reality is that the government has monopolized these fundamental societal functions. And if the government is the only source that people have to enforce their rights and to provide justice, it better damn well be doing its job. In 1959, Murray Rothbard wrote a letter to Kenneth Templeton. And in that letter he said, "I'm getting more and more convinced that the war-peace question is the key to the whole libertarian business." And Murray Rothbard was right. It is the pursuit of empire that causes our liberties to die at home. From the Federal Reserve being created to fund war in the first place, central banking, to the police state, to nuclear brinksmanship, war and peace is the key to the whole libertarian business. And we've seen this as we've sent billions and billions of dollars abroad. We've spent our policy provoking proxy wars abroad. And meanwhile, our fundamental infrastructure at home is crumbling. As libertarians, again, we uniquely understand this. So as we sit here and watch America descend further into dystopia, the responsibility falls on us to take action. So thank you so much. I appreciate the opportunity to speak with you.